Tort in civil litigation, contract and tort claims are by far the most numerous. Tort law attempts to adjust for harms done by awarding damages to a successful plaintiff who demonstrates that the defendant was the cause of the plaintiff's loss. It's important to note that tort is a remedy for wrongs that are not a breach of contract, is one way to describe a tort. So contracts chapter is the chapter upcoming. That is the chapter that deals with breach of contracts. Contracts and torts, two different things. A tort is essentially a remedy for a wrong done that is not a breach of contract. Tort is a French word. A lot of times in the legal realm, a lot of our peculiar words are Latin words. Tort is a French word that means crooked, wrong, bent, that type of thing. Torts, of course, are... Tort law is primarily state law. True or false? That would be true. Tort law is primarily state law. There is not many federal laws in regards to torts. Torts are going to be treated a little bit differently state to state. Tort is a very old law, derived from common law. Legislative branch might have legislated some type of statute that handles tort law specifically, but originally tort law would all be a very old law springing forth from common law. Tort law holds individuals legally accountable for their actions. Contracts, in my mind, contracts are there to keep honest people honest in dealing with one another. Torts are a type of social contract, if you want to think about it that way, in which the community, the society, people, individuals treat each other in a proper manner, and tort laws is one of those checks that keeps us all accountable for the consequences of our actions. Tort is a French word meaning wrong. That is true. Tort versus criminal law, you're going to notice a lot of terms or concepts that are similar and run through tort law and criminal law. That's correct. It's good to notice those similarities, but also understand there are differences. When we're talking about assault and battery in the criminal law concept, it is different from the assault and battery in the tort concept. Tort is a remedy for civil wrongs that would occur in civil court, whereas criminal law is going to happen in a criminal law mindset in criminal court. Torts are divided up into many different ways to help enable us to understand them and to facilitate the laws regarding torts. Torts are divided into torts against persons, property, and economic interests. Types of torts: intentional, negligent, and strict. Intentional torts requires a certain mens res. To take a concept out of criminal law, requires a certain intent inside of our minds. We intended to accomplish that action. That was a tort. Whereas negligence is more of a mistake, more as a failure to perhaps think about one's actions, or the failure to think about the consequences of one's actions, or just simply making some type of mistake. That's negligence. Strict liability, it does not require mens rea, doesn't require an intent. The fact of the matter is, the thing happened, therefore the wrong needs to be redressed. Which of the following is a tort? It's going to be the fourth answer there: a wrong or injury to another other than a breach of contract. This is a great chart in regards to dividing up torts into different types of categories. Take a minute there to look through there, and then we're going to be going to those categories now. We're going to jump more into assumption of risk in a moment, and I'm certain I will use that as an example. A tort is commonly defined as a wrong or injury to another other than breach of contract. That is true. Let's jump on up here. Intentional torts require some intent to do an action. Unintentional torts, negligence, was a mistake. The blank standard is a measurement of the way members of society expect an individual to act in a given situation. Inside of tort law, especially in regards to negligence, unintentional torts, where a person perhaps acted unreasonably, the scale you're going to ask yourself, the question you're going to ask yourself is, if when the person was, let's say, driving in their car and they were doing something in their car in regards to maybe having some fun with music, and they're driving and swerving their car back and forth, and then they go to reach for a CD down below, and then they accidentally, run into another car or something like that due to a mistake. It was an unintended consequence of their actions running into the other car. They were just trying to change their CD and have a good time and wiggle their car around all at once, which we all know is not a good idea. But why? What is the legal standard we would use to say that's not a great idea? That was the fictitious standard created in the legal realm called the reasonable person. Would a reasonable person have acted like that behind the wheel of a car? Strict liability does not require fault. Typically, strict liability is going to occur upon a non-delegable duty, something that is to be held to a high, very, very high standard of care. One of my favorite examples is always the dangerous animal. If I would go ahead and buy myself a tiger and keep a tiger in my house, that's great. I've got a tiger. I might take a huge number of precautions in order to make sure that my tiger never escapes from my house. Nonetheless, due to no fault of my own, somehow my tiger is let out of my house and goes and causes incredible damage to some person or some other pet or something like that. We've heard of dangerous animal laws. A tiger would clearly be a dangerous animal, and there's going to be strict liability upon myself as the owner of the tiger, even though I took all types of possible precautions and I did not intend this consequence. And in fact, I even intended the reverse, that the tiger would never get out and injure someone, but yet somehow it did happen, and that is a non-delegable duty. That is something to such a high standard. Society really places a high threshold or burden upon the person that takes that action, and therefore you're going to have strict liability that thing occurred regardless of the reasonable person standard, regardless of your intention. You are strictly liable for the damage as a result. Which of the following is a condition required for the imposition of strict liability? The fourth one there, an activity that is so inherently dangerous that it cannot ever be safely undertaken. A person who commits a tort is referred to as a tortfeasor. Great term to know. In order to determine whether a duty of care was breached, a court would look at how a reasonable person would have acted in similar circumstances. That is true. Reasonable person standard. Dimensions of tort, nature of injury. Different types of harm can occur. We have harm to persons, we have harm to property, we have mental injury, and we have reputation, and we have economic interests. So you have a tort action being brought against you. Sometimes a tortfeasor has an excuse for their actions. A great example is the assumption of the risk. Assumption of the risk is typically going to, a great example for assumption of the risk is going to be some type of sporting activity, a boxing event, hockey, baseball, skydiving, rock climbing, naturally dangerous activities where one is assuming the risk of what might happen. One thing that you should be aware of is even though you're assuming the risk for risks that would naturally occur along with that type of activity. So here I gave the example of two boxers in a ring. Two boxers in a ring, you're assuming the risk that you might get punched. You're in the ring with two boxers, you could get punched. What's not likely going to occur if you're in a ring with two boxers is that your ear gets bitten off. So a great example of assuming the risk. I'm in a boxing ring, there's a couple boxers around, I might accidentally get punched in the face. That happens, I'm assuming that risk. But I'm not assuming the risk that my ear might get bitten off. Strict liability or torts, where the plaintiff does not have to prove fault or the failure to exercise ordinary care, usually because of the inherent danger involved. And that is correct. This is some great terminology here. Plaintiff does not have to prove fault or failure to exercise ordinary care, failure to act as a reasonable person. They have to show some type of intent that they intended the injury. None of those things apply. Strict liability happens because of the inherent danger of the activity. You don't have to prove those other things. It makes it a very easy case to prove at court. Damages. We have compensatory damages. That's going to be replacement for property, compensation for lost wages, reimbursement for medical expenses. Typically, compensatory damages are going to be calculable. There's going to be some type of math you can use to calculate the amount of compensatory damages involved. Another type of damage is punitive damages. Punitive damages are meant to punish. It's intended to deter people from doing a type of activity by punishing them with additional damage rewards. Nominal damages. Nominal damage is a very low reward for damage. You can think about it as almost the opposite of the punitive damage. This is going to happen where you've got a case where someone did cause a tort to another person, perhaps trespass to land. Someone comes and trespasses on my land. Maybe they're doing it over and over again. Maybe it really annoys me. I sue my neighbor for trespassing on my land because they're doing it all the time. I've asked them 50 times to stop. Well, the court finds, yes, they trespassed on your land. They did cause that tort, but unfortunately, the court can't find any real damage that has occurred to you, and so they might only award you a nominal amount of damages, a small amount like $5, $10, something like that. And of course, you could also probably get some other things done in regards to injunctions, things to stop the person from coming in your yard. But that is just an example I'm using in regards to nominal damages, where the court can't find a high level of damages, or a compensatory. There's no compensatory damages involved. There's no punitive damages involved. But yes, you did win your tort. Here is a nominal amount that you win. Courts only award punitive damages in case which the tortfeasor has committed. Which one of these things? It is going to be the last one. Gross negligence or act with malice or willful intent to harm or complete disregard for the rights of others. It's not going to apply in a negligence situation. Intentional tort, assault and battery. Colloquially, people might say assault and battery and use them as two things that are immediately connected together. Assault and battery are two different things, two very separate things. I'm going to start off with the definition of battery first. Battery requires offensive contact to occur to a person. Contact occurs and it is offensive. That's battery. Being punched in the face, great example of battery. That's offensive contact. It happened. Punched in the face. Battery could also be kissed. I might not want to be kissed. A person kisses me. I find it offensive. It's contact. It's offensive. It's battery. But both of those examples, contact plus offensive. Remember those two elements. Assault is being having a apprehension of a battery is going to occur. The apprehension of a battery. Assault does not require contact. Battery requires contact. Assault requires apprehension of this offensive contact. I would just call it apprehension of a battery. That's the way to think of it. A battery is incoming. I see it. I have apprehension of that. That is assault. Now, clearly, assault and battery can come together. Someone is about to punch me in the face. I see them coming at me. I see them raising their fist. They're definitely going to punch me in the face. I'm apprehensive in regards to this. So far, assault is happening, and then they push out their arm, it hits me in the face, battery has then occurred. Assault and battery happened kind of in a very similar moment there. The assault first, the battery second. All right, can assault and battery happen and be separate? Sure. So someone comes up, acts as if they're going to punch me in the face. It's a reasonable fake out. I think they're going to punch me in the face. I have apprehension. I just have assault occurring, and then they don't actually have any offensive contact. No battery occurs. They don't actually punch me in the face. All we have there is assault, no battery. Can we have a battery without an assault? Sure. That would be someone comes up from behind, hits me on the back of the head with a frying pan. I didn't see them coming. I couldn't be apprehensive about it at all. I had no idea they were going to do it. Boom, they hit me on the back of the head with a frying pan. Battery has occurred, no assault. Robbie calls Bobby on the telephone and threatens to come over and break his nose. Which of the following is true? What is true about that is no assault has occurred, because it needs to be an immediate apprehension of harm. If I call you on the phone and tell you I'm going to punch you on the face, that might be some other tort or some other thing occurring, but it is not assault because there's no immediate apprehension. If I'm calling you on the phone, I am not close enough to you to punch you in the face. Blank damages or compensation awarded to punish a defendant, that would be punitive. False imprisonment is a type of tort where you are restrained and you feel as if you're being deprived of your freedom, that you cannot get out of the situation. So a great trick question here would be someone, maybe you're at Walmart, they think that you were shoplifting or something, they ask you to stay, it's totally a mistake, they put you in the security room and they ask you not to leave, and then everybody walks out of there and they close the door, and maybe in their minds, in the security guards' minds, they've only asked you to stay. They didn't lock you in the room, and they thought you could leave at any time. Well, a reasonable person might think to themselves, or this person here and there, this person here, I shouldn't say a reasonable person, it is that reasonably, let me see, anyone who feels deprived, the textbook is not using the reasonable language. I'm uncertain if it's the person's perspective or reasonably. I believe it's a reasonable perspective, but nonetheless, I don't think any question you're going to have is going to get quite that technical. But it's a person who believes that they are locked up, whether or not they're actually locked up, or what the other person thinks in regards to their intent, whether you can leave or not, reasonably feel that you're being deprived of freedom. Intentional infliction of emotional distress. Typically, this is going to require some, one, it's got to be intentional acts to cause mental and emotional distress. Often, the mental distress needs to be severe, and also the conduct that occurs must be extreme or outrageous. There's an example there about a bill collector, middle paragraph. Trespass and nuisance. Trespass is putting something or someone else going on someone's property, refusing to move it. In addition, a nuisance is sort of similar, but is loss of enjoyment. I'm not going to go into these details here. What you see that's underlined is in regards to landowners' duties to trespassers, and there's a sliding scale in regards to a homeowner's duty to the different types of individuals on their property. When one person places another in fear or apprehension of an immediate offensive bodily contact, this is known as what? It is not a battery. Batteries require contact. Apprehension is assault. A for apprehension, A for assault. Bodily contact actually occurring, that's battery. Blank damages are a small amount of money, that's going to be nominal. Read the rest of the sentence there. Intentional interference with contractual relations. All right, there's got to be a contract. The defendant needs to know of the contract. Defendant needs to improperly induce a third party to breach the contract. And then there was injury to to a plaintiff. Simply offering a better deal is not enough to create liability for intentional interference with contract when only a prospective contract exists. It requires more than that. Courts generally hold that landowners have a duty to protect others on their property from known and hidden dangers. That is true. Malicious prosecution. You can't bring suit against someone when you know that the action, that you have no reasonable belief of winning, and you're only bringing the action just to cause the other person distress. Defamation is injury to a person's good name or character. This harm can be done through spoken word, one person to another, telephone, radio, television. Spoken word is going to be slander. Defamatory statement, when it's published in its written form, it's called libel. Remember that this needs to be communicated to another. So if I'm having a private conversation between myself and another person, and I begin to make statements that would be an injury to their character, if I'm talking about them, to them, and no one else can hear me, that's not going to be slander, that is not going to be defamation, because I am talking to only that person. Sticks and stones can break my bones, but words can never hurt me. Well, at least not in the realm of defamation, directly spoken to one other person. I am not defaming them. Now, if I go to another person or multiple people and discuss this person and defame their character and cause them injury, that's when we're getting slander. That's when we're getting libel. Truth is always a defense. If what you're saying is true, that is not going to be libel or slander. Communicated. This is what I was saying earlier, it needs to be communicated to a third person. If you're talking to just that person, that is not defamation. In addition, the statement that you're making needs to be specific enough that I see, how is it stated here? You need to be able to identify the type of, the person or the group specifically that you're defaming. The statement can't be too broad. Also, this is important, the law of defamation is built on strict liability. That you may, and what this comes down to, is that you may not have intended to defame, meaning that you thought you were speaking the truth. So if I'm going over to others and saying something about this person's character that would injure them, maybe that they were a thief, or they're a murderer, or something else horrific about this other person, I'm telling these people, but I think that it's true, so I'm not intending to defame. Unfortunately, if that is false, even though I intended to say something truthful, it turns out it was incorrect. That can be defamation. So there is a duty of care that one needs to take. In addition, you can also defame in a business sense. You can defame a business